This module is about the Fourth Amendment, the rights and protections there, and as those rights and protections are applied to things rather than to people. So when we're talking about things and houses, we're talking about a right to privacy. And the right to privacy has been established as a constitutional right. Now, you won't find the word privacy or the right to privacy in the constitutional text. But a case called Griswold versus Connecticut from 1965 was an opportunity for the Supreme Court justices to look at various rights that were enumerated in the Bill of Rights and to find that there are sort of shadows or a penumbra of protections. That is, these rights are derivative. It's sort of a necessary thing that is the right to privacy in order to substantially protect these enumerated rights. So when we're talking about privacy, you don't have a right to absolute privacy. We're looking for reasonable expectations of privacy, and there is a definition. There are essentially two elements. The person must have exhibited an actual expectation of privacy, and that expectation that was exhibited, it must be one that society is prepared to recognize as reasonable. So when we're talking about what is a reasonable expectation of privacy, there's a subjective element to it, and there is a more objective element. Would society reasonably think that someone has an expectation of privacy if they have something outside on their front lawn in plain view for all to see? Probably not. What about inside someone's home? Well, it's more likely to be the case. So we have two words, search and seizure. So what is a search defined? When you think of the word search, you're thinking about words like exploration or examination. It's where you're looking around, moving things out of the way, opening things. You're exploring a house or a closet or something like that. Now, what about seizure? A seizure is when you actually sort of take dominion or control or possession over a thing. So oftentimes we say, well, this was a search and seizure. Someone is looking for something, they find it, and then they take possession of it. So that is a seizure defined. So what's the general rule? General rule is you have to have a warrant to do these things. You have to have a warrant. That's the general rule. We'll see in sort of boots on the ground reality, though, that most searches and seizures are made without a warrant, even though the basic general rule is that you must have one. So what are some things that are subject to a search? There are essentially four categories or four types of things that can be searched and seized. So contraband, fruits of a crime, instrumentalities of a crime, and mere evidence of a crime. So contraband could be something like illegal drugs. It could be money that is counterfeit. Those are things that are just not legal. They're almost always illegal for anyone. Counterfeit money, certainly, and illegal drugs, by definition, is illegal. What about fruits of the crime? Well, this could be goods that are normally perfectly legal to possess, but they're stolen. So stolen goods. Instrumentalities of a crime could be a lock pick set or other burglary tools. Right? It could be a weapon that you used to threaten someone. And then we have mere evidence, and that could be if someone was injured or harmed or killed, there could be on the assailant's clothing could be covered in the victim's blood. And if the officers were to come across the t-shirt that was blood stained, that might actually be something called mere evidence. It's literally mere evidence of the crime. A crime was committed, and here is the evidence on this t-shirt. It's blood of the victim. So what law enforcement officers have to keep in mind, and what is subject to examination in the courts, is whether or not a law enforcement officer went beyond the scope of the search. So searches have to be limited in scope, and they must be reasonable And typically the warrant will say how far a law enforcement officer can go. So think about this. Law enforcement officers looking for a sniper rifle. And so has a warrant. Judge has issued a warrant, so you can go into this person's apartment and you can look for a sniper rifle. And so the law enforcement officer goes into the cabinets in the kitchen beneath, and maybe you could fit a gun in there, maybe not, but certainly that sounds reasonable. Closets, certainly. Under the bed, certainly. Between the mattresses, certainly. But what about opening a small box in the closet? A small box, let's say that's 5 inches by 5 inches by 5 inches, almost a cube, 5 inches. Well, a sniper rifle certainly can't fit inside that small box. That is probably beyond the scope of the warrant if the warrant only allows for the search of the sniper rifle. Now, imagine if it also allowed for the search for ammunition. Well, a 5 by 5 by 5 box might have ammunition in it. So it depends on what has been allowed in writing if we're using a warrant. And that's relatively straightforward to figure out. You can read and see. Now, if you're looking for baggies of cocaine, pretty much anything would be open for inspection and examination because little baggies of cocaine can be hidden anywhere. So keep in mind, the search must be reasonable, and it must be reasonable based on the object of the search. Police officers don't have forever to execute a search warrant, and when they are searching, they can't search necessarily for 5 weeks straight. The search cannot last indefinitely, and that's either with or without a warrant. So once the item mentioned in the warrant is recovered, the search must cease. At least that's the general rule. Obviously, you can come up with a scenario where during the search, let's say they find the sniper rifle, and as they're walking through the bedroom, they also see powder cocaine on the dresser, and so that might give them probable cause for an arrest, something like that as well. So there could be other things that might come up, but generally, once you've found the item, the search must be over. You can't have an indefinite amount of time, and you're not supposed to use a legal search as a fishing expedition. So what happens after the search? Well, typically, law enforcement officers are going to make an inventory of everything that was seized, right? We want to give the occupant of a home or the owner of the things a list that have been seized. This is not just a matter of decency. Imagine that something was seized and it turns out that it wasn't actually illegal, or it wasn't actually the thing that was used in a crime. It wasn't instrumentality of a crime at all. We want to make sure that we return that, right? We have some rules that the government's not allowed to just come and take your property. And so an inventory is important, and it's not just so that we can return things to people. It is also that we have an appropriate beginning to the chain of evidence. We want to make sure that things don't get tampered with, and that if at least from the government's point of view, that everything is in its place, has proper identification, and that it goes from signature to signature all the way to the jury. So the inventory is helpful for that purpose. We also want to make sure that, let's say there was dollars, lots and lots of dollars, and they weren't counterfeit, so it wasn't just a contraband, but it might have been drug money, and there was an allegation that it was, and maybe it wasn't. We want to make sure that none of that money goes missing as well. We don't want to turn law enforcement officers into criminals, and so this is just one of the protections for law enforcement officers. Hey, this is we found $763, and by the time it gets to the jury's box, there's still those $763. Keep everybody honest. So even though the general rule is that you must have a warrant in order to search a home, for instance, in reality, most of the searches are not with warrants. But let's look at the general rule. What happens? Well, an officer will go and sort of swear to certain facts that he or she believes to be the case, and a judge will issue a warrant. It's basically an order of the court, and it directs a peace officer to search property connected with the crime and bring it before the court. That's essentially what a warrant is for search and seizure of things. Now, there are 4 requirements for a valid search warrant. That doesn't mean you can't have something that is called a search warrant that a court issued, But in order for it to be a valid search warrant, that is one that can pass scrutiny in later court of appeals, for instance, it must have 4 elements or 4 requirements. First is probable cause has to be there. If you challenge probable cause later on in a motion to suppress, during the trial, after trial on appeal, if you don't have probable cause, then the warrant is not valid at all. It has to have a supporting oath or affirmation, a supporting oath, and it has to have a description of the place to be searched and of the things to be seized. It has to be particularly described, in fact, and then it must bear the signature of the magistrate or the judge. So how do you serve a search warrant? Well, just briefly, it is typically going to be governed by state law. There is a Texas Code of Criminal Procedure, and that is essentially in Texas, where Texas peace officers would go to make sure that they're following the rules. This is to safeguard the officers and to safeguard the people that might be involved and property. So a search warrant is directed to a law enforcement officer. That's essentially who it orders, and it must state the grounds for issuance and the names of those who have given the affidavits in support. So they can be tracked down and later questioned or examined in court even. So what about reality? Now, if you don't have a warrant, we've discussed this in a previous module, it might be a little bit more difficult if heavy scrutiny is applied to whether or not probable cause existed. If you have a warrant, well, you've already had a third-party, uninterested judge essentially say, yes, I find probable cause, and that's a lot of backing and protection for the law enforcement officer. It brings clarity to the situation. But most of the time, searches are conducted without a warrant. So the burden is on the police to prove in court that probable cause existed at the time. Easier to do if you have a warrant, more difficult to do if you didn't have a warrant. So searches with consent, those are the easiest to prove because if someone gives their legal consent, a valid consent to search, then the police officers have every right to go search because they have permission from the person. And so that's the easiest one to overcome if you're in law enforcement. This is why almost not every encounter, but almost every encounter, you're going to have an officer ask if he or she wants to search something. They will just ask, do you mind if I take a look in your trunk? Do you mind if I take a look in your car? Do you have any drugs? Do you have any narcotics? No. Well, do you mind if I take a look? Sure. Well, if that is not forced and it is voluntary, that consent is very powerful protection for law enforcement. So, although the general rule is you must have a warrant in order to legally search, most searches and seizures do happen without a warrant. So it's important for you to understand and to be able to describe and give examples for the exceptions. And so here are 7 exceptions to the rule that searches and seizures must be made with a warrant. The first, we've already briefly mentioned, it is a consent exception. So law enforcement officers who search a house with consent, that is an exception to the warrant requirement. You do not need a warrant if you have consent. Now, there are some parameters there. You can't consent to your neighbor's house being searched, for instance, although there can be some confusion. What we want is to make sure that law enforcement seek authority for the search, for the consent, and a consent search can happen and does happen routinely. There are also searches incident to lawful arrest. So if it is a search incident to an unlawful arrest, it's not an exception. So the search incident to a lawful arrest is widely used. Almost every time an officer makes an arrest with or without a warrant. So if you have a warrant for someone's arrest, you may not have a warrant to search. But if you lawfully arrest them, you can perform, law enforcement can perform a search incident to arrest. So there are 3 justifications. Essentially, we allow officers to do these incident to arrest searches. We want to ensure officer safety, we want to prevent escape, and we want to prevent the destruction of evidence. So we want to protect officer safety, we want to prevent people from escaping, and we want to prevent the destruction of evidence. So these searches, there's a chapter 6, I believe, has a more extensive explanation of these, but that is one of the 7, and it is used all the time. Then we have the exigent circumstances exception, the exigent circumstances exception. This is not a catch-all, but it is a diverse group of situations that could apply. So we have instances of danger or physical harm to the officer. We have destruction of evidence issues. We have searches that are in sort of hot pursuit of dangerous subjects. They enter into a house, we can look for them. If there's a danger to a third person, when there's a DWI arrest, they may take a blood sample. Right? So these exigent circumstances exceptions are diverse and broad and are widely used as well. So the stop and frisk exception we have already discussed. There's a module, a chapter on stop and frisk. Technically, it is a search. You are patting someone down without their permission, so that is an exception. There are the motor vehicle exceptions, the special needs exception, and the administrative searches and inspections exceptions. So in your text, you will learn about all of these. For instance, what if you're a school principal? You essentially, if it's a public school, represent the government. Well, there's some limited things that you're allowed to do without a warrant there. So keep in mind, you must know the general rule, the protections that are articulated in the Fourth Amendment, but you should also keep in mind, especially as you're reading and going through the modules, that most of the searches and seizures that happen in America don't have warrants attached to them.